everyone. Welcome to the first webinar of the 2020 webinar series of European Union Law and Sustainable Development Jean Monnet module. It's an absolute pleasure to be here with Ioanna Hadjiyianni. I hope I pronounced the name well. Who's a lecturer at the University of Cyprus. And today we will be discussing essentially the topic of her most recent book, which just came out for Hart Publishing, the EU as a Global Regulator for Environmental Protection. With me, the academic coordinator of the European Union Law and Sustainable Development module, Riccardo Pavoni, who will say just a few words to introduce our speaker. And of course, also coming from me, thank you, Ioanna, for taking the time to be with us. It's a real pleasure.
Hi, everyone. And it's really a pleasure to have with us Ioanna Hadjiyianni today. We actually identified her as a potential speaker for our webinar series because of a recent book, as Dario Piselli just said, which has impressed us a lot. The book is I want to display this, just the evidence that we have the book and we actually read it. The book is called The EU as a Global Regulator for Environmental Protection, a Legitimacy Perspective. And we actually thought it's a very good combination of theory and practice in this area. Even in the topic is pretty well known. It talks about the environmental legislation of the EU, which may have extraterritorial effects. And I also want to add that this is for us a very important webinar because it's a kind of follow-up to a previous keynote lecture, which we hosted with Professor Joanne Scott. And Joanne Scott was with us in May 2018, discussing sustainable consumption, the geographical scope of the EU's environmental responsibilities. So I think this webinar may be an effective follow-up to that lecture and also an update on that lecture. Ioanna Hadjiyianni, as Dario has said, is a lecturer in law at the University of Cyprus. She received a PhD from the Dixon Poon School of Law at King's College London in 2017, and she also holds an LLM from the University College of London. I don't want to steal other time from her talk, so Ioanna, the floor is yours.
Great. Good afternoon, everyone. I would like to start by thanking the organizers of the webinar series, Dario Piselli and Riccardo Pavoni, for this very interesting series, for setting up this very topical webinar series, and for the kind invitation to contribute to the series. I'm very happy to be here with you today electronically to share some of my research ideas. I would like to share my screen with you so you can follow the PowerPoint presentation. Dario, can you confirm whether this is fine?
Everything is perfect.
Perfect.
Okay, great. So today I will be presenting some key ideas developed in my PhD thesis, which was recently published into a monograph with Hart Publishing. Now, the topic of my research broadly concerns the external environmental regulatory action of the EU, dealing with the relations of the EU with third countries, that is non-EU member states, in relation to environmental problems that are transboundary and global in nature. While the EU's action has been usually studied in relation to its action in bilateral agreements or its active role in multilateral agreements, my focus is on how this extensive action is supplemented by the domestic legislation of the EU that increasingly extends the scope of application of EU requirements beyond its physical borders and influences what third countries are doing in this way. We see this happening in many areas of EU law, actually, in relation to data protection, financial services regulation, competition law. My focus is on how this phenomenon is emerging in the environmental sphere as an emerging technique to achieve sustainable development. I think this is a very interesting field to examine the emergence of this phenomenon and also the legitimacy concerns it raises. Linking it to the topic of the webinar series that we're participating today, the unilateral regulation of environmental problems in an extraterritorial sort of manner presents a regulatory technique increasingly being used by the EU to achieve sustainable development goals globally, in ways that actually raise legitimacy concerns about the appropriateness of the EU to unilaterally decide and determine the balance between the three different pillars of sustainable development, that is economic development, social development, and environmental protection. And doing this by applying its legislation across physical borders and across multiple legal regimes that apply. So I would like to start by introducing the phenomenon of what I call internal environmental measures with extraterritorial implications, or for brevity, IMEIs. These measures are essentially domestic measures, so in their nature, we're dealing with EU directives and regulations that regulate trade, so they impose conditions on the imports and exports of products or the provision of services on the basis of conduct and circumstances that actually take place abroad. They often exhibit what Professor John Scott calls territorial extension, whereby the regulation is based on a territorial trigger between the EU territory and the regulated activity, but as a matter of law, requires taking into account conditions abroad. The book analyzes a broad range of examples which demonstrate both the opportunities but also the challenges for the EU to regulate such global environmental issues. In today's presentation, I will refer to 3 examples as a way of conveying the kinds of issues that the book deals with, but there are more examples that this framework could apply to. The first example that I would like to mention is the IUU Fishing Regulation, which essentially requires fish products imported into the EU to be accompanied by a catch certificate that certifies that fishing, wherever this may occur, including in the high seas and the maritime waters of coastal states, to be carried out in areas where there's specific kinds of third country measures on conservation and management of aquatic resources. So essentially, the EU, as a significant export market, indirectly sets conditions and requires third countries to have specific kinds of measures in place, as well as verification processes to verify compliance. Now, while the IUU regulation incorporates international standards to a large extent, it reinforces them through a robust enforcement framework, which includes the possibility for the EU to actually blacklist specific countries that are failing to control the vessels that carry their flag. The second example that I would like to mention, and the one that you're most likely to be familiar with, is the decision of the EU in 2008 to include global aviation emissions in the EU emissions trading system. This essentially required flights arriving to or departing from EU airports to surrender allowances, essentially to pay for emissions emitted during their trip, including emissions emitted outside of the EU's airspace. So in terms of global reach, this was quite extensive. And it was met with considerable reactions by different countries around the world, and eventually was suspended. But it is still an interesting example to analyze in terms of the attempt of the EU to regulate an issue that fell outside the scope of the UN regime on climate change. And through unilateral regulation, it was able to push forward developments in the International Civil Aviation Organization. Finally, the last example I want to mention relates to ship recycling. This is an area which I've started looking more closely into in the last few months. This is a very interesting and complex regulatory issue. This relates to the dismantling of ships at the end of their operating life. What do we do with obsolete ships? And essentially, this is a complicated activity because ships are usually sent abroad to developing countries, particularly in South Asia, to be dismantled, and they often end up on a beach in India or Bangladesh and dismantled in substandard conditions that often result in injuries or death of workers and pollution of the local environment. Now, this is a complex regulatory issue because in practice, the requirements are often circumvented, either by just changing the flag of the ship and avoiding flag state regulatory requirements, or by avoiding to declare that the ship is actually being sent on its last voyage to be scrapped. The EU adopted the ship recycling regulation, which has a global reach in two main ways. The first is that it requires all ships calling at EU ports to have an inventory of hazardous materials on board, indicating the quantities and the locations of the hazardous material. This will apply from December 2020. Already from the beginning of 2019, the second requirement relates to the conditions under which ship recycling occurs. So the EU imposes conditions on ship recycling occurring in safe and environmentally sound facilities, and this is spelled out in Commission guidance, including these requirements apply to facilities in third countries as well when they receive ships flying the flag of an EU member state. So shipbreaking, I think, acutely demonstrates the difficulty of balancing the different aspects, the different elements of sustainable development, particularly through unilateral regulation. On the one hand, yes, flag states wish to ensure that their fleet are being dismantled in a safe and environmentally sound manner. On the other hand, ship recycling countries, often developing countries, rely on ship recycling as a significant source of valuable materials, especially steel, and as an activity that provides job opportunities to vulnerable poor workers. So balancing all of this, on the one hand, social development requires that you protect workers from unsafe conditions of labor, but on the other hand, taking away the job opportunities by imposing strict requirements is also problematic, as the people who are already facing extreme poverty, that will also be a threat to their health and well-being. So coming back to kind of giving you some sort of idea with the examples, coming back to the more general picture, I argue that actually with these measures, the EU is effectively exercising global regulatory power. It regulates conduct abroad through market access conditions. So it incentivizes rather than compels specific behavior. EU legislation will not usually apply any requirements to third countries when they're not trading with the EU. But in practice, by de facto, given the importance of the EU market, these measures often have significant coercive effects on third country actors. The EU is just too big to ignore, essentially. It's an important fishing market, it's an important airline hub. And indeed, in certain areas, as Professor Anna Bradford argues, we may be facing a Brussels effect, where third country companies will change their production practices across the board, even when they're not trading with the EU, because it makes economic and financial sense. And at the same time, in certain situations, we also see changes, official changes in the legislative frameworks of third countries that adjust their policies to match EU standards. Now, why is the EU engaging in this sort of activity? There are many explanations given in the literature. Usually the EU will engage in this sort of activity when it is an issue that is insufficiently regulated at the international level. So it steps in to fill a regulatory gap. And with unilateral regulation, it also manages to avoid some of the complexities associated with multilateral regimes, such as deadlocks in negotiations, insufficient implementation of standards, and the fact that they usually enable the lowest common denominator internationally. Now, a broad territorial scope is necessary with unilateral action so as to effectively regulate global issues and not create pollution havens or carbon leakage by the activity just being displaced somewhere else. The EU also recognizes that this is done to protect competitive opportunities of domestic industry so that they don't have to face additional and more stringent requirements, and therefore this sort of equal treatment of foreign and domestic industry can level the competitive field. We are definitely witnessing a shift with IMEIs from the EU leading by example to strategically and structurally using the market, the power of its market to incentivize changes in their countries. It certainly does not abandon multilateral efforts, and in most of these measures, there will be an explicit clause saying that the EU is open to either suspending or amending its unilateral action in light of international developments. Now, some of these explanations are more problematic than others, and the big question is, and this is what the book tries to bring out, is what the EU doing necessarily a good thing? Yes, it is pushing forward, avoiding deadlocks of multilateral regimes and actually getting something done. But can we really assume that the EU is acting as a hero that comes to regulate for the benefit of humanity? In fact, I argue that from the perspective of affected third countries, a series of legitimacy concerns arise. First, with unilateral action, the EU can be seen as exporting its standards, its values, its own priorities without sufficiently taking into account local demands and needs, something which challenges conventional understandings of state sovereignty and the principle of self-determination and non-interference. There is also the risk that the EU may be abusing its power, outsourcing its own responsibilities and passing costs on to others, which can be particularly problematic when IMEIs, and they often do, influence developing countries. Finally, because IMEIs by their nature are unilateral measures developed within the EU legal order, we're faced with a situation where those regulated and affected by regulatory power do not necessarily have a say in decisions that affect them or ways of holding the EU to account. So within this context, chapter 2 of the book particularly identifies 3 key legitimacy gaps. The first is an accountability gap, and this is inspired by the work of Robert Kiyosaki, who argues about an external accountability gap in global governance more generally. And this is created because usually the EU, there will be no clear mechanisms for holding the EU to account on behalf of third country interests. There is also the possibility for a creation of a participation gap where third country interests might not have sufficient opportunities to express their views and concerns and potentially influence the formulation of these measures. And finally, a justice gap. This relates both to procedural justice and due fairness when IMEIs are implemented to third country interests, but also distributive justice concerns, particularly relating to the distribution of costs and benefits in relation to developing countries and vulnerable groups within them. So my research recognizes the challenges for legitimizing transnational regulatory power and seeks to identify what is the appropriate role for law in filling these different gaps, particularly by requiring sufficient consideration of third country interests. So within this context, I argue that law can and should serve a dual role. On the one hand, enable the adoption of IMEIs, facilitate a situation, provide the legal basis for a regulating jurisdiction that wants to go a step further and adopt unilateral regulation on environmental issues. However, at the same time, it is important to have sufficient constraints in place to discipline how the EU exercises such power so as to avoid abuse. Both the enabling and constraining functions of law are important for legitimacy, but unconstrained power can really exacerbate the legitimacy gaps. This idea of the dual role of law is used in the book as a lens to identify and analyze the current state of the law, but also in terms of normative assessment to identify ways in which the law should further enable or should further constrain different kinds of action. Now, a big challenge in legally analyzing these measures is the fact that they do not fit within a single pre-established legal framework. EU law, as the home legal system from which they originate, the source of the EU's power, is definitely relevant, but that's not the end of the story. Third country domestic law is also relevant. They're on the receiving side of these measures, and a comprehensive analysis of this phenomenon requires also understanding the legal culture and framework on the receiving side of this regulation. And finally, international law is relevant. That includes public international law rules on jurisdiction, treaty-based regimes that are applicable on the same policy field, so the International Civil Aviation Organization regimes, the IMO regimes, for example, and finally WTO law, which applies broadly and regulates the relations of the EU with third countries in relation to trade. In the book, I focus primarily on a combination between EU law and WTO law to analyze the different ways in which these two mechanisms can contribute to addressing the different legitimacy gaps. These two regimes provide primary sources of legal control and significant avenues for holding the EU to account. So essentially in parts 2 and 3 of the book, the legal analysis tries to identify different procedural and substantive obligations under EU and WTO law that can contribute to filling the legitimacy gaps by requiring due consideration of third country interests. Now, before I look into the key, before I share some key mechanisms under EU law and WTO law that contribute to addressing legitimacy gaps, I would like to briefly mention some constitutional values, both under EU and WTO law, that provide support for the legitimacy argument made in the book, essentially requiring consideration of third country interests. Now, under EU law, there are many different principles and doctrines that could be relevant. My focus is on constitutional and administrative law particularly. So I would like to start by highlighting the EU's external action values, the values to which it commits itself in its relations with the wider world. These include many, many different things. We have a reference to sustainable development, protection of fundamental rights, democracy, good governance, the rule of law, and so on and so forth. Article 21 is actually very long. I only included the introductory paragraph of the article. Now, these values demonstrate, in a sense, the dual role of EU law. On the one hand, they provide the constitutional justification for the existence of IMEIs. The EU adopts unilateral regulation to achieve some of these goals and some of these values. But at the same time, other values indicate that we have to have some limits and take into account social and economic development rights of third countries. References to international law, sustainable development as defined internationally, and respect for the needs of developing countries, for example, are important in terms of the EU also taking into account distributive justice, for example. Now, there are also, of course, many internal values that might be relevant for regulating IMEIs, given their nature as internal measures. And for example, commitments of the EU institutions to function openly, to carry out broad consultations with all relevant stakeholders, including third country actors, requirements for transparency. All of these are quite interesting and relevant for examining in a doctrinal way the legitimacy framework put forward, as explained earlier. And under WTO law, of course, when I talk about WTO law and legitimacy of EU action, there is always the question, is the WTO really the appropriate forum to enhance legitimacy in this way. And of course, I recognize that because of its trade liberalization agenda, the WTO might not be the most appropriate organization to restrict regulatory autonomy of jurisdictions that want to pursue non-trade legitimate objectives. And there are shortcomings of the WTO taking into account development needs of developing countries in particular. But at the same time, as a global organization that is meant to protect the interests of all of its members, the WTO does impose obligations, both of substantive and procedural nature, that require taking into account third country impacts, and this can be enforced before the WTO dispute settlement system. So by its nature, it has a great potential to provide for external accountability and put global administrative law in effect. There are many different agreements which can be relevant for different examples. My focus is on GATT in relation to trade of products, GATT in relation to services, and the TBD agreement, which can be relevant for some examples of IMEIs, potentially biofuels, that might be considered as technical barriers to trade. And here I would like to highlight a quite famous by now paragraph of the preamble of the WTO agreement, which essentially incorporates sustainable development as a WTO objective, while recognizing that environmental protection and the development needs of different countries are relevant. And the appellate body has clarified that such references must add color, texture, and shading to the interpretation of WTO law provisions. So they provide the basis for making the argument of taking into account these different elements of sustainable development. The extent to which sustainable developments has sufficiently influenced interpretation and application of WTO obligations is a different matter, is more complex, and in some ways it has not sufficiently taken into account the development needs of developing countries. But at least it's there, and it is important in terms of making the broader argument. So in the remainder of the presentation, I would like to spend a few minutes to identify and highlight some key mechanisms under both EU and WTO law that contribute to addressing the different legitimacy gaps. In terms of the accountability gap, there is under both EU and WTO law a requirement for justification. The administration is required to justify why the use of IMEIs, why the use of specific regulatory requirements. Under EU administrative law, there is a general duty to provide reasons. At the formulation stage, a quite general reason giving would be enough, but it also applies at the procedural implementation stage when IMEIs are being implemented in particular situations. And this is quite demanding and can also be reviewed by the Court of Justice. The EU is also required to justify trade restrictive measures under the WTO, particularly under exceptions and under the chapeau of Article 20 of the GATT. The unilateral and extraterritorial elements of IMEIs do not necessarily signify that they are violating WTO requirements, but they might require more demanding justification, in a sense. Secondly, we have requirements for transparency. I have mentioned some requirements in terms of EU law. There are commitments in the treaties and in soft law documents produced by the Commission for carrying out decision-making in an open manner and consulting with different stakeholders. There's also a regime of access to information, which, however, has a lot of exceptions which are quite regularly used. The WTO also imposes publication requirements. Members are meant to make their trade policy publicly available so as to allow other members time to adjust to them. And in certain agreements, these requirements are imposed quite early on, even when the policies are in draft form. And finally, legal accountability in terms of judicial review. In principle, third country actors, both individuals and governments, could challenge the legality of IMEIs before the Court of Justice of the EU and before the WTO dispute settlement system. In practice, however, direct access before the Court of Justice of the EU is restricted due to a strict interpretation of standing requirements. And even those cases that would find their way before the court, likely deferential review would be applied, because the court usually prefers not to interfere too much with the discretion of the EU institutions to make tough choices when it comes to political, social, and economic issues. And before the WTO dispute settlement system, all members have equal access, even developing countries, of course, but the practicalities of adjudication, requirements on the burden of proof would, in some cases, mean that developing countries have additional hurdles to face in having access and using the WTO dispute settlement system. So overall, there are mechanisms of transnational accountability there. The extent to which they require for due consideration, and this is happening in practice, is variable. And this is why it's interesting and important to look at both the regimes, at a combination of legal regimes in this context, because a lot of the times the disciplining effect of WTO law within the EU legal order depends on how WTO rules and WTO decisions are incorporated within the domestic legal order. For example, WTO rules, WTO decisions do not have direct effect before the Court of Justice of the EU. And the fact that the EU is a developed member to the WTO, very much familiar with WTO rules, it can design WTO compliant rules and therefore downplay any constraining effects that WTO law might have. Moving to the participation gap, both EU and WTO regimes could function as consultation fora on IMEIs with different kinds of third-country actors. Within the EU, these are usually soft law procedures. Impact assessments are quite interesting in this regard. The EU Commission usually engages in broad consultations with stakeholders, including third-country actors. But we have to realize at the same time that impact assessments create important lobbying opportunities. Big multinational companies will have standard procedures for influencing EU decision-making. The poor fishermen from a developing country might not have as many opportunities to express their views. So we may be facing an unequal representation of different kinds of third-country actors in practice. It also very much depends on how willing the EU is to take into account these views. Much depends on the framing of the issue. And I have looked at different impact assessments on the different measures. For example, the impact assessment on ship recycling puts considerable emphasis on the positive impact of the ship recycling regulation. No consideration of the negative economic impacts that would detrimentally affect the job opportunities of vulnerable groups of people. No consideration of how third-country facilities would cover the costs of adapting to EU standards, and a strong presumption that EU action will end up being effective and not being circumvented in practice, which is quite problematic. Under WTO law, committees and councils, so for example, the TBD committee or the Council on Services, could function as fora of consultation. Particularly in the TBD context, there are important ex-ante notification obligations. So members have to notify new technical barriers to trade when they're in their draft form and provide time for third countries to raise their concerns. And this can happen under the context of special trade concerns and discussed at the multilateral context. Now here, much depends on the willingness of the EU to actually engage in a discussion in the WTO forum. For example, in relation to sustainable criteria on biofuels, the EU has consistently refused to discuss this issue in the WTO and instead invites developing countries to engage in bilateral negotiations. Finally, the justice gap, which I would say is the one that is least addressed at the moment. In terms of procedural justice, there are many procedural justice rights in EU law that can be relevant. The right to be heard is a significant one. and it is important and can be reviewed by the Court of Justice. The WTO also imposes due process requirements, which can function as an external layer of obligation, putting pressure on the EU. And here again, much depends on the EU's willingness to meaningfully engage with these procedural steps and not just treat it as a formal tick-boxing exercise without sufficiently taking into account the interests of third-country actors. And finally, distributive justice. Despite EU external action values and commitments to sustainable development, to take into account the special needs of developing countries and protect fundamental rights, in practice, there is no clear relationship between the EU's unilateral action and the provision of development aid to developing countries, and the application of the Charter to protect fundamental rights of vulnerable communities in third countries influenced by the EU's unilateral action is underdeveloped. Under the WTO, despite the reference to sustainable development and some influence of sustainable development and the special needs of developing countries on the interpretation of certain obligations, in general, we see that the development needs of developing countries in the interpretation of different provisions is not very demanding and fails to take into account those concerns. So to conclude, I would say that at the moment, EU and WTO law are both balanced towards facilitating and enabling EU unilateral action without always providing sufficient constraints for disciplining how the EU exercises this power. I'm not arguing that the constraining function should prevail to entirely restrict unilateral action, but I do believe that further consideration of third country interests is needed to enhance the legitimacy of the EU's action and to truly reflect the EU's commitment to achieving sustainable development globally and taking into account all the three pillars of sustainable development. Thank you very much for listening, and I look forward to your questions and comments.
Well, thank you so much, Ioanna. It's been an extremely interesting presentation. The floor is already open for questions. I will collect some if there are any. First of all, if Ricardo has any question, I'll just or comment, I'll just give the floor to him. Also, I have some questions on my end too. Ricardo.
You go first, Daniel. You go first. Okay,
super. So my first question, driving directly maybe with a question on the the recent kind of hot topics in the news, to try to refer to something that's been increasingly discussed, and which is of course the role of the EU in potentially introducing a EU carbon tax, essentially carbon border tax for polluting carbon-intensive goods, which is of course a proposal that's been discussed a lot, which is probably will be a core part of the vision for a Green European deal and so on. So I just wanted some thoughts on for what we know, of course, on that type of measure as an expression of this global regulatory power of the EU, especially considering that it can raise interesting legitimacy question, if you ask me, because it would be something that's been kind of brought up not just as something directed at developing countries, but potentially something that applies to extremely developed countries, of course, like the US. So it creates probably a different type of legitimacy questions there. I just wanted to hear your thoughts on that.
Yeah, so I think this idea has been there for a while. I think it is a provision in one of the revisions of the EU ETS directive, and it has always been considered. And I think one of the reasons why it was abandoned was because of the reaction to the Aviation directive. So actually, the only example out of the examples that I discussed that has targeted developed countries was the Aviation Directive, the proposed Aviation Directive, and which was the only one that was sort of successfully suspended, if you want, in terms of developed countries actually having the power to resist to what the EU is doing. So in terms of the carbon border tax, I think it very much resembles the aviation example, and I think there will be definitely resistance from developed countries. The problem is, as you said, these are sort of different kinds of legitimacy concerns, because these countries on the receiving side will have much more power to resist, potentially through the WTO, in terms of challenging the use of a tax, which is always, in terms of the EU, taxes, especially in relation to environmental goods and climate change, are always quite controversial, because they raise issues also internally, vertically, on the competences between the EU and the member states. So I think it's a very interesting example, and I think some of the legitimacy concerns I raised are still applicable in this sort of regime. But I think we'll also have to see, in terms of regulatory power, how the conflict between developed countries and the EU sort of develops. So it's sort of a space to be watched. I still haven't formulated my thoughts entirely on this, so it's something that I think it's worth looking into as we move forward.
Yeah, and it's also a bit difficult to sort of form thoughts on this. The more as an issue, it gets talked about, but still delayed in terms of, I guess, also recently it was sort of mentioned that we probably are not going to see any substantive kind of proposal until later on this year or next year as well. Riccardo, on your end, anything?
Yeah, I would like to make just a very general comment on Ioanna's presentation, which I think is, like her book, very, very interesting and thoughtful. She never mentioned the word consistency, which to me it's a very important word and expression in this context. Because I think that we may end up concluding that as a whole, on the whole, these measures, internal legislation by the EU with extraterritorial implications, is good. It's not that bad. There are some legitimacy concerns which have to be tackled, etc., etc. But as a whole, this kind of unilateralism is beneficial to sustainable development because the positive things outweigh the negative sides of this problem. But on the other hand, I have this consistency dilemma in my mind. Even in the past, I've worked on this, because I think that consistency here may take different shapes, different forms. On the one hand, if the EU is so in favor of this kind of unilateralism, then I don't see why the EU shouldn't allow particular member states to pursue this kind of unilateralism in the area of environmental protection. And this is a problem which is well known, because there are many cases before the European Court of Justice where a particular unilateral action by a member state has been found unlawful under EU law because it's violating the exclusive competence of the EU in this area. Probably the most important example is the PFO case, where Sweden tried to include unilaterally, made a request before the Stockholm Convention bodies to include 2 new chemicals in the list of prohibited persistent and organic pollutants, and that action, the unilateral action by Sweden, was found unlawful by the European Court of Justice. So this is a kind of, policy, the kind of, let's say, course of action by the EU institutions, which is has always been controversial to me, because I don't see why a particular member state such as Sweden, which is very much progressive in the area of environmental protection, shouldn't do the same as the EU is doing. So this is a consistency problem. On the other hand, consistency may also assume a larger dimension here, because of course, these unilateral measures by the EU may be beneficial to the environment and sustainable development if they are well crafted, etc., etc. But on the other hand, if we want to pursue in a genuine way the sustainable development goals, the EU should also try to fight against the overexploitation of natural resources, which is beneficial to its own internal market. So I don't see why. I mean, you have to you limit. You pose the EU is imposing a lot of limits on fishing by third countries. But where is that? Where are those fishing resources heading for? They are heading for the European single market as one of the most important markets in the world. So I think there's also a problem when we're discussing with Joanna Scott last year this goal, Sustainable Development Goal 12, sustainable consumption and development. I think she started in the right way by underlining that here the problem is also the overexploitation of natural resources by the developed countries, and especially in this particular case by the EU, or the production of waste, or the production of food losses, etc., etc. So I think this, the problem has two sides, and should be tackled across the board. I don't know if Ioanna wants to make a comment about this, or she has any particular thought on this.
Yeah, I think consistency is, I love this comment because it brings out a lot of the legitimacy issues from a sort of different perspective. And in terms of the first sort of point you make about allowing unilateral action by member states, it is quite interesting also when examining the case law of the court, we see an entirely different approach. So we have, and I use, for example, the principle of proportionality to make this point, that internally, proportionality is something entirely different, because we start with mutual recognition, and anything that the member state does that's going beyond what's necessary is not acceptable. And actually the court goes into a lot of detail examining any unilateral measures imposed by the member states. When it comes to unilateralism of the EU, and we have had some cases with actually both EU actors and non-EU actors challenging what the EU is doing, especially in animal welfare cases.
Yeah.
There,
we see problems.
No proportionality assessment. The EU is allowed to do it. There's no presumption of equal treatment. And it is quite astonishing to see how is this a consistent approach to unilateralism. And I think it is quite interesting, and also I think it is quite problematic, because it sort of creates an inconsistency in how the EU is acting internally and externally. And in terms of consumption, and I think Professor Scott now develops an idea about the complicity of the EU in creating these problems, and whether it has sort of an ethical role in all of this. And I think this is the core of the idea. When I say that I think the EU might be outsourcing its responsibilities, it's in the sense, for example, ship recycling. EU fleets are huge, and ship owners in the EU take, benefit from the operational life of the ship. They make money out of it, and then when it comes to treating it as waste, we just send it somewhere else. It becomes too expensive to do it within EU member states. So now we're just moving it into developing countries and not really dealing with it. And as you said, what about actually fighting over exploitation within the EU? And for example, with ship recycling, why not pre-clean the ship, take away the hazardous material on the spot, and then send it to the other end of the world, where it will be dismantled with bare hands, essentially. So I think there's so many issues there. And yes, I agree that unilateral action is useful. It can be beneficial for sustainable development, but there are many different ways to do it. And there are still a lot of concerns that remain unaddressed.
Thank you.
Super. So I wanted to follow up with one question that's been asked by our Facebook. I'll sort of try to summarize it. And it's essentially a question of, it sort of touches on something that Riccardo was saying before, which is sort of the, aside from the legitimacy, how can we compare that? How can we balance that against the dimension of effectiveness and the environmental effectiveness of these measures in improving environmental outcomes and legislation in environmental legislation in third countries. And essentially the concern here is also, given that you mentioned that sort of the competitiveness concern that sometimes spurs these measures, the concern is, to what extent can these measures actually block sometimes these sort of environmental improvements when the main effect that they have is sort of preventing producers from developing countries from entering markets, and so essentially block access without actually having a sort of a capacity building effect, supporting the development of legislation in third countries. Is it something that can be seen as beneficial in this case?
Okay, I think there's about 2 or 3 questions in there, actually. So in terms of the effectiveness of these measures, when I first set out doing this research, I was really interested in finding the effectiveness and measuring the effectiveness, which is always really, really difficult to do and requires empirical research being done as well. So this is something that I haven't looked at in great detail yet. We do have some areas where it's really obvious that other countries are adopting similar requirements, or at least trying to implement them on the ground. A lot of the times, however, they're not entirely effective, because also the jurisdiction of the EU is much greater in terms of prescription, and it cannot really enforce and check the enforcement of these measures on the ground. So whether they actually contribute to achieving a better environmental outcome is still to be assessed. It's not a given, which I think is quite problematic. Now, in terms of blocking entrance and using trade restriction as a way of incentivizing changes, I actually think that blocking entrance can have detrimental effects. So, for example, in terms of IUU fishing, if you identify a country as blacklist, as being non-cooperating and including it in a blacklist, or even before including it in a blacklist, it has a yellow card. So it's sort of a warning that it will be included in the blacklist. That already has huge implications on the fishermen. And it is at country level, so that's also quite problematic. It captures everyone who has the flag of that member state, of that third country. And I think this is an argument made by people who have done some empirical research on this as well, that capacity building is promised by the EU sort of once the country is identified as non-cooperating. The problem is providing the capacity building before you block access and at a sort of an earlier stage. So in terms of the case that I am planning to do some empirical work on ship recycling, I am really wondering, now they're in the process of authorizing different facilities in third countries, when they're not actually included in the list, but they have made the effort to comply with the regulatory requirements of the EU's regulation. What happens then? Is there any provision for capacity building, for providing financial aid so that the requirements can be met? What about all of the effort they've tried to do, but still they haven't reached that high requirement of the EU? Just simply blocking them or not recognizing them doesn't mean that the polluting activity will stop. It will just mean that there are loopholes for avoiding those requirements as well. So I think, I'm not sure if I've answered the question, but I think it raises some very key issues in that regard.
Happy to direct any follow-up from the reader, the viewer who sent the question.
Okay.
No, okay.
It's always hard to give an answer with these issues. It's mostly usually just thoughts and opinions.
Clearly. Ricardo, do you have anything? I see that we have another comment here on the YouTube, and then I have also maybe a very small question. But Ricardo.
No, perhaps the only comment would be, if Ioanna has any thought on, because of course everybody knows that the EU is not the only one in the world adopting this kind of unilateral approach or extraterritorial approach. Probably in the past, the most famous measures were those adopted by the United States of America, and we know that, for example, the WTO case law about shrimp, about tuna, we all know those cases. So another concern that comes to my mind is that, of course, I thought that, I've always thought that unilateralism is a good thing in the environmental protection area. But then, if you have many different standards arising from different economic blocks, that could be another concern for developing countries, because then the market becomes very fragmented, and especially developing countries have to comply with different standards. So this becomes very burdensome for developing countries. So I think, I think that there should be a good balance between multilateralism and unilateralism in this area.
Mm-hmm.
Just a general comment.
Mm-hmm.
Okay, so
with the last question on YouTube.
Yes. So the question on YouTube kind of builds upon what we were saying before. What is sort of I guess my first question on the proposals for carbon border tax, and the question is from Mauro. He's asking whether you think that legitimacy concerns, which is what we were mentioning, will affect any EU proposal for a revision of the ETS and then maybe a carbon border tax. And I might ask also, whether you think this will be sort of some object of maybe international negotiations or something.
So you mean international negotiations on a carbon tax?
Or whether, or at least some sort of discussions maybe, and this is not part of the question, sort of I added it on top of my head, off the top of my head as I was reading the question, but will this be some sort of level of maybe political discussion before the EU actually goes forward with this?
Okay, now in terms, let me just first say something about Ricardo's comment before I go to the final question. Completely agree that some coordination of any sort of multiple unilateral regulations coming from different economic blocks is necessary. And I have to give this credit to the EU legislative design that usually, and it is quite innovative, they have a clause saying that this will be revised in light of any international developments. We're willing to coordinate with any sort of third country measures. So for the Aviation Directive, for example, there was a provision that if the third country from which the flight is departing adopts a similar legislation, we will negotiate and come to a sort of optimal interaction between our unilateral measure and their domestic measure. So I think this is really important. I think in most areas, the EU is kind of aware of that and has come back to revise in light of international developments. So I think that is a key point. In terms of legitimacy concerns being taken into account in the revision of the EU ETS and the adoption of the carbon border tax, I don't know if the legitimacy concerns will be taken into account. I hope that they will. At least internal legitimacy concerns that have definitely risen in terms of the EU ETS problematic nature. And I think in terms of the carbon tax, it is important to identify third country actors as important stakeholders. And I suppose there should be an impact assessment, some sort of discussion before it actually is being introduced. Although impact assessments are usually carried out for new sort of legislative measures. If it's an amendment to an existing legislative measure, I'm not entirely sure whether it will be an impact assessment or some sort of online consultation, because this have now become quite common practice. And they provide very sort of accessible and useful ways for input by different stakeholders. The problem is how much effort the Commission makes to make the relevant stakeholders aware of this consultation in time, provide the necessary information to be able to meaningfully give some sort of input so as to allow for the legitimacy concerns to be taken into account. And then it is up to the Commission and the EU institutions how much they will take those concerns into account. So I think it is something that we'll have to come back to in terms of the carbon border tax. I think there will be some very interesting development happening very soon.
Dario, I think we have covered a lot of ground, and we don't want to abuse Ioanna's time.
No, absolutely. I don't know, maybe just one very little thing that I had just had in my mind. I wanted to ask for 30 seconds really, and then we can wrap it up, which is something that you mentioned in the book. I mean, a distinction that you make in the book, and it's also made by Joan Scott, and people who have written before on this, which is can legitimacy really be seen as the same type of issue in the case when the EU is trying through its environmental policy to enforce an internationally agreed standard, as opposed to when it's trying to more directly kind of export a unilateral standard that relates to some internal piece of legislation?
Okay, so this is something very interesting. Thanks for that question. In my book, I think that it doesn't make much difference, because the mere enforcement of international standards through the EU's unilateral market power already makes it problematic. So even if you take the international standard as it is, so for example, in the IUU Fishing Regulation, you take the standards of the regional fisheries management organizations and you impose it through a blacklist, that's an entirely different thing. Because I think enforcement and implementation are very important. The third country might have not consented to that international standard if it had known that it would be enforced in that way. So enforcing it in that way, it already makes it something different. And most of the times, even if the EU incorporates to a large degree international standards, it usually goes beyond that. So if you read the ship recycling regulation, it will say we're implementing the standards of the Hong Kong Convention. But actually, in the guidance, it's going much further than that in the technical standards. So I think the starting point, there is a point there that if you're imposing international standards which have already formed the subject of international negotiations, it's not so problematic. But I think even the mere enforcement of those international standards through the EU's trade restricting approach raises the legitimacy concern. So I recognize there are different degrees of unilateralism, but I think even incorporating international standards into such a demanding framework already raises legitimacy concerns.
Super. Thank you so much for the very sort of quick response, but very effective. We don't want to, as Ricardo was saying, abuse your time.
No, I enjoy talking about these things always.
Super. No, it was extremely interesting and very, very lively as a debate at the end of your interesting presentation. I maybe just give just 1 second of the mic to Ricardo if he wants to say something to close it, and then we can wrap it up.
Yeah, I will refrain from more questions. Perhaps I will ask more questions when I will meet Ioanna live one day. And I just want to wrap up the discussion by thanking Ioanna so much for being with us. It's been a very interesting and engaging discussion, and we do hope that we will have further opportunities for collaboration in the future.
Great, thank you very much.
And thank you from myself, Ioanna. It's been really a pleasure. It's been also a pleasure to have different people engaging with us. And I, of course, mention that it is possible for everyone to connect to the link and watch this webinar recorded on YouTube from the very moment where we end it. So it's very good for rewatching, which we probably will do. Thank you again, Ioanna, and happy afternoon to everyone.
Thank you very much. Bye.
Bye.